From the iHeartMedia Studios, A Professional Edge by Sean G. Todd, tax attorney CPA and certified financial planner, is providing general information related to taxes, investments, and estate planning. This information is not to be perceived as providing individual legal, tax, or investment advice, as each individual's circumstances are unique. Being a listener does not create an attorney/CPA or an investment advisory client relationship. Each individual's personal situation is different, and seeking one-on-one advice with a licensed professional is recommended. Securities and fee-only investment counsel is provided through Schwab Institutional Member SIPC. This is Professional Edge, a program designed to help you understand the importance of getting counsel and advice from a licensed professional and help you appreciate the significance of being able to integrate your investments, tax planning, and estate planning into one cohesive plan to prevent an unintended consequence. We will be talking with Sean G. Todd of Estate Management Counselors, LLC. Estate Management Counselors, LLC is an independent fee-only investment management firm based in Atlanta with a satellite office in Columbus, Georgia that serves select clients throughout the country. Their goal is simple: to make sure their clients feel confident and secure about their financial future. Sean is a truly qualified professional. He is a licensed tax attorney, a CPA, and certified financial planner. He is also an adjunct income tax professor at the University of Georgia. One unique thing you might not know about Sean: he attends the National Rodeo Finals each year. We will be talking with Sean.
Thanks for listening to The Professional Edge. My name's Sean Todd, tax attorney, certified financial planner, host here on The Professional Edge for north of 5 years. Today we are actually talking about Beyond the Will, your comprehensive estate planning. What does that mean, beyond the will? Well, a lot of our listeners have a last will and testament, and raise your hand, you're one of the 50% of individuals that do have an estate plan. But unfortunately, half of all our listeners here on The Professional Edge do not have any sort of estate plan in place. We actually know that all of us are not getting out of this alive. So here's your impetus to move forward. We all are going to need some sort of an estate plan document in place, because if we don't have one, that's called dying intestate, and the great state of your domicile state is going to have their own estate plan in force for you. So by example, on the estate in the great state of Georgia, you die intestate and you're married and you have 2 kids. Well, a lot of us think that everything is going to go to that surviving spouse, and that unfortunately is not correct. In the great state of Georgia, law of descent and distribution is going to say, yep, your surviving spouse is going to get half of that estate. But then what about the other half? Well, we're going to move the 2 kids up in line with the surviving spouse, so we're going to have 3 beneficiaries of that next 50%. So when your kids, let's say they are 3 years old and 5 years old, yes, they are going to move up in line for that surviving spouse, split that 50%. And upon reaching the age of majority, that's the great age of 18, they're going to get a check for their balance. So let's think that there's some life insurance here. We got a home, we have some equity, we have some investment accounts. Well, guess what? When they reach the age of 18, that money's probably going to double twice. So you're talking about a couple $100,000 in a very simple estate that's going to go to an 18-year-old with unfettered access. So therefore, we set them up for failure. We're giving an 18-year-old a couple $100,000. We don't know what they're going to do with it. So that's another wake-up call for getting your estate plan in force. At least get a will, because half of our listeners, unfortunately, don't have any estate planning documents. So right there is the impetus to give our office a call at 877-654-9798. That number again, 877-654-9798. To schedule that complimentary consultation on getting your estate plan in force and in effect. So when we say beyond the will, well, here's the one thing beyond the will. We come across actually this past week an individual who said, yeah, I got a will. And I said, okay, that's great. How old are your kids? And then he's like, well, 32. And the other one's 28. And I said, okay, when did you draft your will? Well, after the second child was born. I said, okay, when was that? And he says, about 30 years ago. Wow. Okay. So at least they had a will in place, but there are so many things that are outdated. And when we started gathering the information on this individual's estate, well, we come up with a number that was, we had some home equity value, we had some life insurance, we had some group life insurance through work, and lo and behold, we had a value of his estate in excess of $1 million. It's easy to get to that number. So again, this child is going to receive this $1 million divided by two, $500,000 for an individual that's 28 years old. If something happened to both the husband and wife, wow, that, think to yourself, when was the last time you received $500,000 unbridled? You could spend it, fritter it away however you want. Well, so step back beyond the will. He had a will, but it was not updated. That's number one. And I'm sure he didn't have an estate of $1 million plus when his two children were born. Not a wealthy family, just a good, hard-working, blue-collar family, accumulated some money, did the right things right. So when he had that original will, we didn't have a lot of assets. Well, now, fast forward 30 years, we do have some assets in this estate. It's $1 million. So beyond the will, what are we going to do beyond the will? Well, here was the first suggestion. One of the children are already entered into a second marriage. So we have this potential creditor situation to go forward with. So beyond a will, let's say that we are going to still give these assets to the kids in equal shares. Got it, if there's no surviving spouse. But we don't need to give them $500,000 outright. Let's protect it from potential creditors. So my suggestion or recommendation was that we give each of the children $100,000. They can go remodel their bathroom. They can use this to update their cars. They can take a trip, do whatever they want to do. It's theirs to squander, blow, invest, do whatever they want. But then we're going to take their balance of that inheritance and place that in a trust for their benefit. Now, is that controlling things from the grave? The answer is no. What we are doing is actually putting a creditor-proof fence around that inheritance. I'm going to say that one more time. A creditor-proof fence around the remaining $400,000. So we can assign the child to be their trustee, and we are going to assign the child to be the beneficiary. So now the child has access to that, and we can tie it up real tight, or we can leave it real loose, like tying a bow on a present. We can make it real tight, and therefore we got a lot of restrictions, or we can make it real loose because the child is there. They're very financially prudent. Just depends on the situation. So we have the $400,000 that is theirs to access based on some conditions. And then we can say, you know what, in 5 years, we're going to give you half, or in 5 years, we're going to give you a third. And then in 5 years later, we're going to give you a third. And the final balance comes out at the end of 15 years. It's however you want to structure that. But here's the key of being beyond a will. Well, we establish this testamentary trust for that child. It is 100% creditor proof. What I mean by that is if this child who is in the second marriage, and we all know the number, 80% of all second marriages end in divorce. That's the number that we're coming across. And 50% of all first marriages end in divorce. So we got to address that if we're being honest with what's going on in society. So let's protect that $400,000 from any claim of that largest potential creditor, which is an ex-spouse. So I got an 80% chance of this relationship not working out. I would rather have that $400,000 sitting in an irrevocable credit-proof trust for the benefit of my son or daughter instead of having all $500,000 of this inheritance going to them outright. And you know what? They're probably going to take the money real quick and commingle it with other marital assets. And boom, you just expose that to the largest potential creditor within this estate. So this is planning beyond the will. This is you have a will. That's great. You want to leave it to your kids in equal shares, but let's structure it just a little bit differently so that way we protect it from the potential claims of creditors and possibly protect them from themselves, meaning the kid is a spendthrift. So we can set it up to where yes, they get this $500,000. We're going to give them $50,000 because we know we're going to spend all of that, and take the other $450,000, place that in trust, and make the trustee pay them a monthly stipend each and every month. We can structure it that way. So again, this is planning beyond the will, your comprehensive estate plan. So if this is of interest to you, or if your son or daughter is in this rocky relationship, or you just don't have that gut feeling that this thing's going to work out for them, let's go ahead and put this in place. And you know what? You got to do this before you pass away, because we can't put these assets in that testamentary trust if you leave it to them outright. So if this is concerning to you, do give our office a call at 1-877-654-9798. That number again, 877-654-9798. The other thing, a lot of people don't know tax attorneys sit around and talk about estate planning, or who do we turn to, or where do we even get started? Well, go ahead and visit our website at emcadvisors.com. That is Echo Mary Charlie Advisors.com. And there is a free Ultimate Estate Plan Guide there that you can request, and we would be happy to send that out to you. We'll even cover the postage for that. It is a great starter kit for your estate plan. So if you're a listener here on the Professional Edge and you are one of those 50% that have no estate plan in place, then go ahead and request that. That gets the conversation started. The Ultimate Estate Plan Guide, and that's available for free. F-R-E-E, free. Yes, something is free. We're not going to have the surcharge on paper like we have the surcharge on eggs right now. So that is there available to you. That website, emcadvisors.com, Echo Mary Charlie Advisors.com, and request your Ultimate Estate Planning Guide. So we're talking about beyond the will. How do we make sure that our heirs are going to keep the assets in which you give them when you pass away? Well, we can do the same thing when the surviving spouse is going to receive their estate from you, the decedent. Well, beyond the will. A lot of you have this I love you will. If I pass away first, says the husband, I'm giving everything to you, my beautiful bride, and off down the sunset. My beautiful bride does not survive me. We're going to give it to the kids in equal shares. That's called an I love you will. Well, here's the downside of that. People are living longer. We have a life expectancy, guys, mid-80s. Women, late 80s. So with that life expectancy, and you pass away, unfortunately, with a heart attack at age 65, your bride is going to live for another expected 20 years. Do you think she might meet someone and get remarried again? Well, high probability. So if she does that, and she then signs an I love you will, what just happened? Well, that new husband or new bride got or is going to receive all of the estate. And I'm not sure that's really what you want to do, because that new husband or new bride has no legal responsibility to the children of that first marriage. So why don't we leave and assure that your children are going to have part of their inheritance from the first spouse that passes away? Now, we don't want to hamstring the surviving spouse, so therefore we're going to put this in a testamentary trust, and we're going to allow the surviving spouse access to this based on some conditions. And then when the surviving spouse passes away, even if they got remarried, they can't move these assets to that new husband or new bride. If that's of consequence to you and you want to make sure your kids are not disinherited, Give our office a call at 877-654-9798. That number again, 877-654-9798. My name's Sean Todd, tax attorney, CPA, certified financial planner, host here on the Professional Edge. We're going to have more coming up on Beyond the Will, your comprehensive estate planning. And thanks for listening to the Professional Edge.
We've all thought about it. Everyone listening will need one. Not having one can cause untold heartache, family conflict escalating to the point of a lawsuit. One simple thing that avoids all that: an effective estate plan. As a practicing tax attorney, Sean Todd with Estate Management Counselors has completed over 1,000 estate plans during his 15 years of professional practice. He can help you implement an effective estate plan, coordinate your financial accounts, and make sure you have named the proper beneficiaries to maximize your tax savings. Call 877-654-9798 today and let tax attorney Sean Todd help you implement an effective estate plan. Call 877-654-9798 today. As a tax attorney, CPA for over 15 years, Sean Todd has implemented over 1,000 individual estate plans. He has recently authored an especially helpful guide, How to Unlock the Ultimate Estate Plan. This guide has helped many individuals to understand the benefits of an estate plan and how to avoid unintended disasters. Sean has made every attempt to write this in plain English. To receive this valuable guide, How to Unlock the Ultimate Estate Plan, call 1-877-654-9798 and request your complimentary copy today, or by emailing your request to info@emcadvisors.net.